Now, I am going to dictate a legal passage at the rate of 160 words per minute. 5, 4, 3, 2, 1, start. Let's start. The petitioner filed a suit for a specific performance of an alleged agreement of sale dated 15/7/2003. The trial court dismissed the suit by judgment and decree dated 19/5/2008. The High Court dismissed the petitioner's appeal. Both the courts held that the petitioner had not approached the court with clean hands and that he had failed to prove any concluded contract for a sale. High Court found that the defendants in the suit were also not above in their conduct. It found that both sides were guilty of having lied on oath and deserved to be prosecuted on the ground that courts were overburdened with litigation. The High Court decided that instead of directing prosecution, heavy costs should be levied on both the petitioner and respondents to be paid to the state, which spends money on providing the judicial infrastructure. It then proceeded to impose exemplary costs of rupees 1 lakh on the petitioner and rupees 1 lakh on the respondents, and directed that the cost should be deposited with the Delhi High Court Legal Services Committee. Feeling aggrieved by the dismissal of his appeal, the petitioner is before this court on merits. We find that the concurrent findings of the trial court and the High Court do not warrant interference, and therefore this is not a fit case. So for grant of leave, the learned counsel for the petitioner submitted that levying cost of rupees 1 lakh against the petitioner was not warranted. He submitted that as the appeal before the High Court arose out of a civil issue to costs were covered by section 35 and 35A of the Code of Civil Procedure and cannot exceed what is leviable under those provisions. Under section 35 of the Code, award of cost is discretionary but subject to the conditions and limitations as may be prescribed and the provisions of any law for the time being in force. Under section 35A, compensatory cost for vexation claims and defenses may not exceed to rupees 3,000. Further, the primary object of levying cost under section 35 and 35A of the Code is to recompense a litigant for the expense incurred by him in litigation to vindicate or defend his right. It is therefore payable by a losing litigant to his successful opponent when an appellant or a plaintiff has already paid the prescribed court fee in regard to the appeal or suit to the state at the time of institution. It is debatable whether any cost can be awarded to the state by way of penalty in a litigation between two private parties. One view has been that the provisions of section 35 and 35A of the Code do not in any way affect the wide discretion vested in by High Court in exercise of its inherent power to award cost in the interest of justice in appropriate civil cases. The more sound view, however, is that though award of cost is within the discretion of the court, it is subject to such conditions and limitations as may be prescribed and subject to the provisions of any law for the time being in force. The Honorable Supreme Court considered the issue at length and held that ordinarily it is considered desirable not to restrict the delinquent's right to be represented by counsel or an agent of his choice, but it is different thing to say that such a right is an element of the principles of natural justice and denial thereof would invalidate the inquiry. The right to be represented by counsel or agent can be restricted, controlled, or regulated by statutes, rules, regulations, or standing orders. A delinquent has no right to be represented through counsel or agent unless the law specifically confers such a right upon him. The requirement of rules of industrial dispute insofar as the right of hearing of the delinquent is concerned cannot and does not extend to a delinquent to be represented through counsel or agent. The Honorable Apex Court held that refusal to grant the help of a lawyer is to be examined on the touchstone of the doctrine of prejudice, and it cannot be claimed in contravention to the statutory rules. The Honorable Apex Court further held that in a domestic inquiry, reasonable opportunity should be given to the delinquent employee to meet the charge framed against him, and it is desirable that in such an inquiry, employee should be given liberty to be represented by a person of his choice if there is standing order against such a course being adopted, and if there is nothing otherwise objectionable in the request made by him. But in a case where the standing order of the employer company provides that in domestic inquiry only a representative of a union which is registered under the Trade Unions Act and is recognized by the Company Act, there can be no denial of natural justice if the request of the workman who insisted to be assisted by a representative of his own unrecognized union with the object of indirectly obtaining recognition to their union is rejected. Stop. Thank you.